The International Criminal Court is now in session. Oh, you're muted.
I keep forgetting to unmute. Good morning, my name is Peter Kremer. I'm the presiding judge today. I'm joined by Sarah Bafadhel as my co-judge. Unfortunately, you only have us. That may be a good thing. We don't know who our other judge, we know who he would have been, but he has some internet issues and can't join us. So, just so you know, it makes it difficult for us because we have to agree. With three people, you can always dissent. Anyway, I would ask the prosecution team to introduce themselves and to tell us about how they're going to divide their team, and then equally from the defense side, and then we'll begin. Prosecution.
Good day, Mr. President, Your Honors. My name is Salma Kamila, and I will be the first oralist for the prosecution. I will speak for 13 minutes, whereas I'm accompanied with my co-counsel, Ms. Rosemary, who will speak for 12 minutes. Separately, Ms. Kalvinka Prawinata will serve our rebuttal.
Okay, before the defense speaks, I just want to advise that Judge Nsereko has just joined us. I don't see him on the screen yet, but he may be here soon, but you don't have to worry about only having two judges. Defense, please, introductions.
May it please the court, good morning, Your Honors. My name is Basanti Mardamutu, and I will be acting on behalf of the defense in this manner.
Alone?
Yeah, just,
okay.
I'm so sorry, Your Honor, I forgot to mention, I am alone and therefore will be reserving the entire 25-minute slot.
Okay, you don't have to use it, you know that. Okay, welcome Judge Nsereko. He's gone.
Do you see me?
I had seen you, but I don't see you now.
What happened?
Now I see you.
Thank you. Sorry, internet problems.
Okay, well, hopefully we'll get through this without any further problems. I'll call upon the first speaker for the prosecution to make submissions, please.
Thank you, Mr. President, Your Honors. Good day, Mr. President, Your Honors. My name is Salma Kamila, and I am deeply honored to appear before this honorable court with my co-counsels, Ms. Stephanie Rosemary and Ms. Kalvinka Prawinata. We will be pleading on behalf of the Office of the Prosecutor in the case concerning crime against humanity of enslavement occurring in the Fire Republic under the superiority of Mr. Bliss. For the next 25 minutes, the prosecution submits 4 issues, and I shall address the first and the second submissions on how this court has jurisdiction over the case, under the case is admissible, whereas my co-counsel will address the third and the fourth submissions of interest of justice and criminal responsibility of Mr. Bliss. Separately, Ms. Prawinata will serve our rebuttal for 5 minutes. If there are no preliminary inquiries, I shall proceed to my submission. May it please the court. Your Honors, in the present case, the Earth Bowers have been the victims of ill-mannered government agenda aimed to control, also justify their brutal actions under the guise of national peace and security. The Earth Bowers were first forbidden to exercise their beliefs, oppressed, and even worse, mislabeled as terrorists. And all the more, they are further deprived of their liberty, mistreated, and enslaved. Your Honors, turning to the first submission, enslavement has varied ever since the establishment of International Military Tribunal up until the present case of International Criminal Court. Article 72C of Rome Statute has established that enslavement exists when an accused exercises any or all of the powers attaching to the right of ownership over a person or more. Affirmed in the elements of crimes and many past jurisprudences, exercise right of ownership can be manifested by depriving the victims of their liberty and thus subjecting them to forced labor. Your Honors, this is exactly what happened in the Fire Republic. In the present case, it is not just mere deprivation of liberty. It is unlawful and arbitrary deprivation of liberty conducted in a huge-scale manner towards the victims, at the very least 30,000 Earth hours. Without due process nor any prospect of trial, the victims were being put in isolated and heavily guarded detention center. Their effort to liberate themselves from such imposition were responded with live fire. This certainly breaches non-derogable fundamental right of human being, which is the right to live. Even after being released, their passports remained confiscated, restraining themselves from freedom of movement. These extreme measures taken by fire government under the guise of national peace and security surpass and breach standards set upon international law, and therefore shall establish that there exists deprivation of liberty in the present case. Beyond such, Your Honors, on the second layer of specific elements, this right of ownership was further exercised by appropriating the victims to forced labor. In today's proceeding, prosecution would like to set forth that there are three factors to establish the existence of forced labor, differing from past jurisprudences of ICTY, Kunarak, and Kernoyalak. First, the absence of the free will of the victims to do labor work. Second, the absence of substantial compensation given for their labor services. And the last one is the subjection of the victims to inhuman conditions. Your Honors, firstly, in 2001 ICTY case of Kunarak, the consent of the victims was rendered impossible when the victims were subjected to threat, use of force, deception, or detention. Presently, the victims have never rendered their genuine consent to do labor work. The only choice they had was to work 12 hours every day of the week, or else they would be subjected to the coercive, violent acts by the armed BNS agents. This situation, Your Honors, leaves them in no way able to render their consent faithfully. Secondly, the Earth hours were substantially uncompensated for their service. The reduction of their sentence is unacceptable form to compensate the detainees of their workloads plus mistreatment there. Lastly, Your Honors, the Earth hours were further treated inhumanly. Apart from being subjected to excessive involuntary labor, BNS agents set up imposition where detainees should face scarcity of food and water, public humiliation, undermining their human dignity during the punishment of standing in extreme winter when they were unable to work. And Your Honors, it does not stop there. There is also blatant denial of rights to exercise religion, identity expression, which exceeds the prohibition to speak native language. These foregoing circumstances create strong state of vulnerability of the victims and thus establish that they were imposed to inhuman conditions. Your Honors, with the Fire Republic exercising power of right of ownership over these victims, we assert that enslavement did indeed occur in the present case. Moving on, Mr. President, Your Honors, we would like to enlighten the court that establishing crime against humanity shall also be conducted within the contextual attack pursuant to Article 7.1 of Rome Statute. Accordingly, the prosecution submits that enslavement is in fact part of systematic attack deviously manifested pursuant to a policy with knowledge of resident of the Fire Republic, Mr. Bliss. Turning to the first point, the systematic nature is reflected through the organized nature of violence and improbability of the random occurrence entailing pattern of conduct. It is evident that the attack in the present case is systematic. We submit that through government crackdown, discrimination, institutionalized oppression, subjective labeling, and human rights violations, all these related atrocious occurrences targeting Earth hours happened far-fetched from random occurrence. Furthermore, there is a clear pattern of conduct in the repeated arrest and detention. Therefore, we submit that the attack is indeed systematic. In addition, Your Honors, these conducts forming an attack are tied by and pursuant to a policy. Rome Statute nor elements of crimes have never envisaged that policy shall be formalized. Accordingly, we submit that the policy is manifested in the actions of Fire Republic to actively take full control over a black man, which has become the basis of the atrocities happening aftermath. Lastly, Your Honors, the prosecution further submits that Mr. Bays had knowledge of the attack. Rome Statute, Article 30, Paragraph 3, which further elaborated in the elements of crimes, knowledge here is established by awareness of the accused regarding the circumstances. And this does not entail that the perpetrator to know every single action within the attack. The fact that in the present case, Mr. Blaze signed anti-extremism executive order insinuates that he had awareness of the circumstances in Blackmount, and this issuance of order entails him monitoring his subordinate, even knowing situation in the detention center, exemplified in the Exhibit 1. This renders it improbable that Mr. Blaze had knowledge of circumstances, and thus it is sufficient to establish reasonable grounds to believe that Mr. Blaze did indeed have knowledge of the attack.
I just interrupt there. Is it only Exhibit 1 and Mr. Blaze's communication with Ms. Ursa that you rely on to show his knowledge, or do you have other facts that you would rely on from which to draw that inference?
Your Honor, we can see also in Exhibit 2 that through these excerpts of signation of the office of the president, we submit that he must have knowledge regarding the circumstances, because everything that happens within his office entails him monitoring it. And therefore we submit that the Exhibit 1 and Exhibit 2 could suffice reasonable grounds to believe that Mr. Blaze had knowledge of the attack.
And what facts do you rely on to show that he had knowledge of the enslavement or forced labor? The forced labor, let's deal with that.
Your Honor, in answering that question, the element of knowledge in this submission does not need to entail that Mr. Blaze should know every single action and detail of the crime. What we need to establish is the awareness of Mr. Blaze concerning the circumstances of the crime. To that, the prosecution submits that as seen in Exhibit 1 and Exhibit 2, Mr. Blaze knows about the circumstances of the enslavement through the direct communication that he had with Ms. Azila during the arrest and detention of at the very least 30,000 earth hours, along with him further authorizing the request of materials to the sanctuary through his office. And therefore, it is sufficient to establish that Mr. Blaze had knowledge of the attack and also the crime against humanity of enslavement in the present case. Honorable members of this court, reiterating the prosecution submissions as the specific elements and contextual elements have been established, the prosecution submits to this court that the case indeed falls under the court's jurisdiction, and the court shall exercise its power to adjudicate the present case. Your Honors, we shall now move on to our next submission regarding admissibility. To enlighten this court, under this admissibility submission, the burden of proof lies on a defense counsel as the challenging party. In this submission, Mr. President, Your Honors, prosecution would like to prioritize the most important and contentious issue, which is whether the amnesty given to Mr. Blaze can bar the prosecution before the court. Accordingly, Your Honors, the prosecution submits that the case is admissible, as prosecuting the case would not breach the complementarity principle under Article 17(1)(c), which read in conjunction with Article 20, paragraph 3, as Mr. Blaze has never been tried on the merits of the case on the national level. On the first ground, under Article 17(1)(c) of Rom Statute, the court shall only be barred from prosecuting the case if such prosecution breaches nebis in idem principle, which prohibits a person to be tried twice for the same conduct. In order to invoke nebis in idem principle, the Chamber in 2019 ICC Gaddafi case and in 2010 Bemba case has required that there must be, first, a completed criminal trial at the national level, resulting in a final judgment of conviction or acquittal. Second, such trial shall be pursuant to formal investigation and prosecution. Your Honors, the prosecution submits that Mr. Blaze's amnesty is invalid to bar prosecution before the court, as Mr. Blaze only appeared before a judge and has never been tried on the merits on the national jurisdiction. The judge in the granting amnesty process only assessed procedural requirements stipulated under Law Number 14, but not on the substantial conduct of the accused within the crime. Consequently, the final judgment of such amnesty does not earn res judicata decision of conviction or acquittal, but rather a fraudulent res judicata. which has no legal effect upon prosecution before this honorable court. In any case, the prosecution submits that the exceptions under Article 20, paragraph 3 of Rome Statute applies. Mr. President, Your Honors, the amnesty granting process is not conducted independently. As echoed in the 2014 ICC case of Sanusi in the admissibility challenge, the independence incorporates free from involvement of inter alia parties to conflict. The fact that BNS, a party to conflict, is involved in the amnesty process alone showcases that there exists lack of independence here. Moreover, as the amnesty terminates all investigation and prosecution, it will certainly lead to impunity and Mr. Blaze's evasion from justice. This court shall never condone the applicability of amnesty in the international crime, specifically crime against humanity for high-ranking perpetrator, which in the present case is Mr. Blaze. Therefore, by virtue of the purpose of the court to end impunity, we implore the court to establish that amnesty given to Mr. Blaze cannot be invoked before the court and that the case shall be admissible. Herewith, the prosecution attests that align with the purpose of the court. First, the case falls under the court's jurisdiction, and secondly, the case is admissible before the court. My co-counsel, Ms. Stephanie Rosemary, will continue our submission of interest of justice and criminal responsibility of Mr. Blaze. Thank you.
Counsel, before you pass on, I have one question. You say that the amnesty process was not independent, was not impartial. What do you say about the fact that ANG was part of the process of the agreement and the reconciliation process? Wouldn't that go towards showing independence?
Your Honor, if I may direct this court to the legal basis of ICC case of Sanusi admissibility challenge, the parties to conflict shall never intervene or involve in the process of trial itself. The fact that only BNS agents in the granting amnesty process involved in the amnesty process itself of public apology showcases that there exists lack of independence here. And therefore, the case, the amnesty given to Mr. Blaze, the granting amnesty process is lack of independence. Herewith, Your Honors, Mr. President, the prosecution attests that align with the purpose of the court, the case falls under the court's jurisdiction, and secondly, the case is admissible before the court.
Counsel, I want to take you back to what you said about Blaze on the issue of mens rea. You referred us to the Exhibit A, and there we find Lord Blaze showing concern that these detainees may be too much. Doesn't that negate the element of mens rea that is concerned that he was not supporting what was going on? Could you comment on that?
Your Honor, on answering that question, Article 30, paragraph 3 only insinuates that knowledge is established by the awareness of the accused. The fact that Mr. Blaze had awareness of the condition in the detention center itself suffices the contextual element of knowledge, and therefore we submit that Mr. Blaze had knowledge of the attack itself in the present case. My co-counsel will continue our submission, and thank you. May it please the court.
Thank you. Mr. President, Your Honors, my name is Tiffany Rosemary, and I'll be further continuing the prosecution submission. As we move on, I will further address two main submissions, which is in relation to interests of justice and the criminal responsibility of Mr. Blaze under Article 28B of the statute. May it please the court. Mr. President, Your Honors, in assessing the interests of justice, the prosecution has taken into account several factors, such as factors stipulated under Article 53, paragraph 2C of the statute, which includes assessing the gravity of the case, the role and infirmity of the defendant, and the interests of the victims. Additionally, Your Honor, the prosecution has also considered other relevant situations pertaining to the case as mandated by the prosecutor's policy paper on interests of justice, such as in the present case, Fire Republic's national peace and stability, and the existence of alternative justice mechanism. Your Honor, that these circumstances are inadequate to establish the prosecution of Mr. Blaze to not be in the interest of justice. Separately, the prosecution would like to firmly also establish that under Article 53, paragraph 2c of the statute, the interest of justice assessment is a discretionary power where only the prosecution has the capability to assess, and in doing so, contradictory to the jurisdiction and admissibility submission where positive assessment are required in the interest of justice assessment, there is no need for pre-trial chamber determination if the prosecution concludes that a case is in the interest of justice. This issue, Your Honor, has also been reaffirmed in the Afghanistan Appeals Chamber, where the chamber has held that the pre-trial chamber cannot make any positive determinations outside of what the prosecution has already submitted. Your Honors, this also means that the defense counsel does not have any legal standing to challenge the interest of justice assessment and to provide its reasonings before this chamber. Therefore, the arguments brought up by the defense counsel do not have any legal weight in this current submission. In any case, Your Honors, there is always a presumption in favor of investigation and prosecution, and that until the current date, there has never been a case where assessment of interest of justice has led to the withdrawal of an investigation and prosecution from this court. Mr. President, Your Honors, as there are no circumstances and situations pertaining to the case which can establish that Mr. Blaze's prosecution does not serve the interests of justice, therefore the prosecution would turn into our next submission, that is the criminal responsibility of Mr. Blaze.
I just have one question. Do you have any case law supporting your argument that there is a presumption in favor of investigation and prosecution?
Yes, Your Honor. Certainly, the presumption of in favor of investigation and prosecution comes from the Office of the Prosecutor Policy Paper on Interest of Justice. Therefore, that is the legal basis that we are submitting to the court, Your Honor.
But no, you have no court decision from either this court or another international court.
Your Honor, the prosecution cannot provide this court with any case. However, what we submit in the present case is in other cases up until current date, there has never been a case where assessment of interest of justice has led to the withdrawal from an investigation and prosecution. Therefore, there always a presumption in favor of investigation and prosecution, Your Honor.
Okay, thank you. Please continue.
Thank you, Your Honor. Mr. President, Your Honors, turning to the prosecution last submission, we will now turn to Mr. Blaze's responsibility as a civilian superior for the crimes against humanity of enslavement in Nsereko under Article 28B of the statute. On the first point, Your Honor, the main contention in the present case is whether or not the delegation of leadership to the BNS agents to Ms. Azila through the anti-extremism order can exempt Mr. Blaze as the person who is most responsible for the crime. To that, Your Honor, the prosecution submits that, as stipulated in the celibacy case, the jure authority itself is insufficient to entail civilian superior responsibility, as what is required is that of actual possession of effective authority and control, which shall be manifested by not only the jure authority, but also de facto authority. Accordingly, the prosecution submits that not only by the virtue of Mr. Blaze de jure authority as president over the BNS and Ms. Azila, but Mr. Blaze also exercises de facto authority by his capability to issue numerous orders, such as the anti-extremism order itself, the authorization of materials to Nsereko, the transfer of detainees in Nsereko and other centers, which were then directly obeyed upon by both Ms. Azila and the BNS. Thus, it is still Mr. Blaze who actually possesses effective authority and control over them, Your Honors. Even more, Your Honor, despite having such effective authority and control, Mr. Blaze has also consciously disregarded information that clearly indicates the risk that the crime was about to be committed by the subordinates. Despite the lack of ICC jurisprudence on this issue, Your Honor, the celibacy case offers that this entails the idea of willful blindness, where the superior simply ignores the information within his actual possession that there exists risk that the crime is being or was about to be committed. In the case of a civilian superior setting, Your Honor, this information can be gained in the form of documents related to their work-related activities. Your Honor, in the first place, as seen in Exhibit 1, on 14 December 2018, the exact date when the 40,000 Earthbowers were unlawfully arrested and transferred to Nsereko, Mr. Blaze and Ms. Azila was engaged in direct communication, where in the first place, Mr. Blaze gave warnings of a possible mutiny, and Ms. Azila further reported the conditions happening in Nsereko, including that the detainees were working, and even requested Mr. Blaze to provide more men and supplies, which in response to this, Your Honors, as seen in Exhibit 2, just days following the communication, the Office of the President further authorized the request of such materials, which includes engine, rubber, glass, and steel. The prosecution reaffirms, Your Honor, that as corroborated through not only heroic testimony, but also the aerial footage, the enslavement in Nsereko, which occurs particularly in mid-December to January, involves activities concerning automobiles. And therefore, Your Honor, in light of this, we submit that the fact that Mr. Blaze further authorizes the request of such materials through Exhibit 2, despite already giving warnings of a possible mutiny, entails that there exists reasonable grounds to believe that Mr. Blaze had clear information about risk that the enslavement was about to be committed, but he decided to not act upon such information, Your Honor. And lastly, Your Honor, despite his capacity as a superior and upon being aware of the commission of the information that the crime was about to be committed, Mr. Blaze failed to take necessary and reasonable measures to repress the crime. Referring to Bemba, Your Honor, this duty rises when upon knowing a risk of a possible chain effect that the crime is about to be committed, the superior is obliged to take measures to stop it from happening. Unfortunately, Your Honors, Mr. Blaze did nothing and further allowed for the delivery of materials which are then used as tools to further the enslavement. Your Honors, honorable members of this court, in light of the aforementioned submission, the prosecution again reaffirms that the end never justified the means, and that the atrocity in Fire Republic in the hands of Mr. Blaze and Ms. Azila under the guise of national peace and security must be condemned before this court. And accordingly, Your Honor, we request this honorable court to adjudge in favor of the prosecution as the right first step to ensure justice, not only for the 30,000 victims, but also for others who remain unknown.
Thank you
Your
very
Honor,
much.
we may not be offered assistance. This concludes our submission. Thank you, and may it please the court.
Thank you. Any questions from my fellow judges? No? Okay. Defense, please.
May it please the court. I will make 4 submissions to your honors today. Firstly, that this court does not have jurisdiction. Secondly, that this case is not admissible. Thirdly, that pursuing this case is not in the interest of justice. And lastly, that Lord Blaze is not criminally responsible for the alleged crime. Starting with jurisdiction, my apologies. The defense accepts that the requirements for temporal jurisdiction under Article 11, as well as jurisdiction ratione loci and ratione personae under Article 12.2 are met. The issue in the current case regards subject matter jurisdiction. An analysis of subject matter jurisdiction looks at constitutive elements as well as contextual ones. Now, Your Honors, it suffices for the defense to prove that only one of these elements is not met for there to be a lack of jurisdiction. Despite both elements not being met, the defense focuses solely on the contextual elements. The crime against humanity of enslavement requires that the crime is carried out as part of a widespread or systematic attack against any civilian population with knowledge. Your Honors, the prosecution did not discharge its burden of proof when discussing the contextual elements. The learned counsel of the prosecution only discussed the systematic nature and knowledge requirements, but did not prove that the attack was targeted towards any civilian population carried out in pursuance of a policy. We contend that these contextual requirements are not met. And I will make 3 points to this end. Firstly, there was no attack against a civilian population. According to the decision pursuant to Article 74 in the Bemba case, at paragraphs 152 to 154 and 673, a civilian population is comprised of those who are not taking an active part in the hostilities, as opposed to the legitimate combatants or members of the armed forces. The people detained in Center Rig were members of the AANG, a separatist movement whose leaders have been designated as terrorists. Even if there is a number of civilians amongst those detained in Center Rig, as outlined by the unsubstantiated statements by Mr. Heru Rock, the defense submits that this represents an incidental target of attack. Recalling the situation in the Republic of Côte d'Ivoire at paragraph 33 of their 2015 decision, to prove that there was an attack directed against a civilian population, the civilians must be the primary target of this attack. Secondly, there was no state or organizational policy at play. Recalling the decisions in Bemba, as well as the situation in Côte d'Ivoire, but most importantly, the elements of crimes document, there has to be an active promotion or encouragement of the attack against the civilian population. In addition to this, we see upon application of this requirement in the 2014 judgment pursuant to Article 74 concerning Katanga at paragraph 1106, it clearly indicates that the course of conduct constituting the attack must be executed pursuant to or in furtherance of a policy to commit such attack originating from the state. Your Honors, the defense contends that this suggests that there must be a policy to commit the crime of enslavement itself, which the prosecution has failed to prove. Referring to the bucket of factors, if it may be coined as such, from the Ntaganda case, in which the court took into consideration a list of factors, we see when applied to this case that there are several crucial elements missing, including, but not limited to, the fact that Lord Blaze did not ever make any statements encouraging attacks to take place in Center Rig. Your Honors, moving to the last point regarding jurisdiction.
Just before you go on, leave that point. How do you deal with Exhibit 1, where the first comment from Lord Blaze is, "Good morning, Ursa, is everything under control?" And that follows the attacks and arrests of 40,000 earthbowers, and it follows the government crackdown against earthbowers in the summer of 2018, which involves frequent arrests and detention of the priests, violent disbanding of public gatherings, and the listing of all AANG leaders as terrorists without due process until 2019. It seems to me that on those facts, it establishes that it was widespread. There was a state policy, and he was aware of it. He was aware of the fact that these people were being rounded up, arrested, and sent to Center Rig as a detention center, at the very least.
Your Honor, I will tackle your question in two parts. Firstly, a difference must be noted between detention and enslavement. The imprisonment of people post a conflict has happened before and and someone can argue that it is a normal course of event that post a conflict, some imprisonment and some detainees will be imprisoned for certain acts that had occurred previously in the conflict. However,
including family and children?
Your Honor, this is where we argue that if there were indeed family and children, as per the unsubstantiated comments by Mr. Harry-Rock, then they only make up a very small minority of those detained and were incidentally wrapped up in the bigger conflict, which had to do with Fire Republic asserting its territorial integrity during the initial conflict. Your Honor,
isn't that question of fact to be left to the trial court to determine whether the population was so small it's minimal and therefore it is not an attack against the civilian population or not?
It is indeed, Your Honor, but we have no evidence to disprove the fact that it was not a minority. So with the evidence that the court has at present, we can only speculate to the fact that it was anything more than a minority. Even if that was the case, the civilians would still have to have been the primary target for the attack, for there to have been, for the court to have jurisdiction in the matter at hand. Now, Your Honor, if I could go back to the first part of your question regarding Exhibit A. Exhibit A and the first statement made by Lord Blaze. Lord Blaze was aware that there were educational centers. The defense does not contend that Lord Blaze did have knowledge of the conflict that occurred for many years, that Lord Blaze did know that educational centers exist. However, this piece of evidence where Lord Blaze states, "Is everything under control?" is a normal sentence to ask to an organization which is handling a center dedicated towards the rehabilitation of thousands of people. It does not insinuate under any circumstance that enslavement is happening. Your Honor, enslavement is very specific. Enslavement refers to and is aimed at completely dehumanizing the victim and making them lose all sense of their personal autonomy. The fact that Lord Blaze asks if everything is under control does not represent that he knew that the crime of enslavement was happening.
Yeah, I focus on the fact that there were 40 education centers, 100,000 prisoners. During the general crackdown between 2015 and 2019. But in September, when the specific crackdown about which Lord Blaze is talking, there were 40,000 people arrested, and they were all to be sent to Center Rig and accommodated by moving 10,000 prisoners to Center Lotus, it is. And the site of the crime that is being alleged by the prosecution is Center Rig. And so we have some evidence that women and children are sent to Center Rig. We have some evidence, and we can argue about the weight to be given to that evidence, that the prisoners were made to work under inhumane conditions, 7 days a week, 12 hours a day. And you're asking us to ignore all of that and simply say, well, there isn't enough proof that it was the civilian population that was attacked, but the attack against the civilian population took place over 4 years in various ways, and but it started and continued in various components. The priests were arrested, etc. So I'll let you continue, sir. But you can deal with the general concern I have.
Yes, of course, Your Honor. And I would like to address that concern in two ways. First of all, the evidence that shows that people were moved from Center Rig upon the arrest of further detainees to another center actually demonstrates that when there was an indication of possible overcrowding, the necessary measures were taken to ensure that overcrowding did not occur. And that resulted in moving some people to another location. Secondly, the point about the forced labor that Your Honor made is in direct relation to the constitutive elements of this crime, which the defense hadn't mentioned, but the defense is happy to go into. Your Honor, under Article 7.2 of the Rome Statute, enslavement refers to the exercise of or of any or all powers attaching to the right of ownership with the requirement that there's a commercial transaction. In the case at hand, there's no commercial transaction. However, the defense notes the cases of Ntaganda and Katanga, which said that in application of Article 7.2, in some situations, you don't need a commercial transaction as long as the servile status is imposed. The people who were detained in Center Rig were not reduced to this status, as there was no deprivation of liberty above and beyond what you would expect at a center which is aimed at the rehabilitation of those actively involved in the conflict. In addition to this, there was no specific there's no specific further evidence to show that any of the things that Hirara can say can be further substantiated. Your Honor, with this, and if I may proceed to the knowledge requirement under jurisdiction very briefly before moving on to admissibility and interest of justice.
But counsel, there were 100,000 detainees in this rig center rig, and I heard you contend that there was no direct attack against the civilian population. Were all these military people, 100,000 people in this center?
Your Honor, based on the evidence that's currently available, it seems that for this case at hand, there are 40,000 people enslaved at Center Rig, not 100,000. It's stated by the case fact that a lot of people were released shortly after, but it's those who are terrorists that would have to stay longer. And the defense contends that this is, again, reiterating that imprisonment can be something that happens after a conflict, but that there still needs to be evidence that brings what is happening from detention to the crime against humanity of enslavement. If there were injustices done in detention in Fire Republic, then the defense argues that this is something for the domestic courts to take care of based on the constitutional rights of their people. However, we are discussing today the international crime against humanity of enslavement, which requires a very different threshold. And the threshold for enslavement is significantly higher, and we do not currently have the evidence to prove that this higher threshold of the crime against humanity of enslavement was indeed met.
And when Lord Blaise says these people were terrorists, therefore we have to accept that they were military ipso facto, just because whoever you represent says they were terrorists, does that make them military and an object of attack, legitimate attack?
Your Honor, two parts to this answer. Firstly, the AANG leaders were designated as terrorists, and I understand your point that just because the government designates a group as terrorists does not necessarily mean that they are. However, upon reading the first report established by the Truth and Reconciliation Commission, which was established at the bequest of the AANG members themselves, it was found in the Truth and Reconciliation's first report that both sides of the conflict committed crimes. Therefore, even if the designation of some leaders as terrorists does not suit this court's threshold, it can be argued that those involved in the AANG and those who played an active part in the hostilities have committed a certain level of crimes, and therefore have this designation as an armed group, not necessarily a terrorist group, but they are at the very least an armed group involved in a non-international armed conflict. Your Honors, for the sake of time, the defense will now move to the question of admissibility, where the defense would only like to emphasize the fact that there are 4 points regarding why the amnesty law number 14, as well as the Truth and Reconciliation Commission, make up the threshold required to establish that Lord Blaze has already undergone the legal procedures assessed by a court of law for the act which is the subject of this complaint. Your Honors, the Rome Statute does not require a prosecution and or a criminal trial in the traditional sense of the word to take place. The Gaddafi case mentioned by the prosecution does not mention the need for a criminal trial to take place. Recognizing amnesty laws does not fall outside the scope of this court's capabilities. Taking Article 17(1)(a) as an example, there is no reference to the kind of investigation that ought to take place. As such, it could be understood that an investigation does not have to be of a criminal nature as long as there are mechanisms in place for providing accountability and proper redress. Your Honors, it is a misconception to believe that granting an amnesty is in effect the decision to denounce accountability and or justice. What happened in South Africa following the creation of its Truth and Reconciliation Commission is evidence that retributive justice, as that carried out during the Nuremberg trials, for example, is only one path to ensuring accountability and redress. In fact, depending on the situation, restorative justice is more suited to the needs of the community. And this is exemplified in this case, as I mentioned earlier, by the fact that the AANG were the ones who requested the establishment of the Truth and Reconciliation Commission and who partook in the peace negotiations. Your Honors, this case does not fall into one of the recognized exceptions to Article 17(1)(c), namely that of shielding, which is the most relevant in the case at hand, as there was no proof of political interference, nor was there proof of institutional deficiencies. Your Honors, there is also no
proof. Can I just interrupt? I have a problem with your submission from the point of view that Lord Blaze apologized for the victim, for the atrocities committed by Azila and the BNS, but he denied any knowledge about the labor camps and said he would have acted differently had he known, but he didn't accept any responsibility per se, and he explained that he knew about the educational program. So there is no admission of responsibility for the crimes that were supposed to be resolved by the Truth and Reconciliation Commission. How do you deal with that fact?
Your Honor, he didn't apologize for it because he didn't know it. And this has direct link to the fact that Lord Blaze did not possess any information which would have made him aware of the commission of this crime, which falls under one of the requirements for criminal responsibility under Article 28b. Your Honor, Article 28 states that Lord Blaze must have either known or consciously disregarded information that was clearly indicated to him for him to have knowledge. And based on the evidence that we have, Lord Blaze would have not known about the enslavement and that the enslavement was occurring as an ordinary result of things. Therefore, we contend that Lord Blaze did not specifically apologize for taking responsibility in the amnesty because there was no responsibility to be taken. Lord Blaze did not have any knowledge of what was happening in Centerrig, and the response and he mentions Ursa Azila correctly because the responsibility when he appointed the Minister of Interior created at least a few degrees of separation between him and the minister. In fact, all communication between them was restricted to administrative purposes. And I argue, Your Honor, that he tried to mitigate as much as possible the overcrowding. I hope that this answers Your Honor's question, but I can elaborate further if Your Honor does.
No, you're running out of time, so please continue your next point.
All right, no problem. So As I was saying previously, there is no evidence to suggest that there was any lack of willingness on behalf of the state to prosecute. And we can see that because if people chose not to go through the amnesty procedure, then they would be subject to the more traditional sense of a trial, right? The amnesty procedure in this manner is elevated to the same level as your traditional criminal trial in this respect. Your Honors, briefly going through the points regarding the interest of justice. As opposed to what the Learned Counsel for the prosecution has stated, and as highlighted by the 2015 decision on the request of the Union of the Comoros at paragraph 15, this chamber is under full right to exercise its independent judicial oversight on any decision taken by the prosecution when it comes to interest of justice. Both the 2016 decision concerning Burundi and the decision concerning Afghanistan state that there are substantial reasons that the chamber should take into consideration when assessing a prosecution's decision that the case is in the interest of justice. These include judicial, legal, and non-legal reasons. The defense argues that there are both legal and non-legal reasons at play. Most importantly, the fact that according to rule number 69 of the ICC Rules of Procedure and Evidence, all evidence needs to be, the case must be pursued with all available evidence. The Truth and Reconciliation Commission, Your Honors, has just released its very first report in December of 2020. There is still more evidence to be found, collected, investigated, and reported on. And the absence of this evidence demonstrates the prosecutor's low prospect of meeting both its evidentiary and legal burdens at trial. Your Honors, now moving on to criminal responsibility.
Counsel, can I just clarify, the Comoros decision that you just referenced, wasn't that in relation where the prosecution decided not to investigate? So how do you differentiate here where they clearly are wanting to investigate? Why is this still a factor for us to consider?
Because even though the decision for the prosecution was not to investigate, the methodology that they relied on when bringing this case to the chamber is still the same, Your Honor. The bottom line is that the defense is using the fact that this case existed to prove that this chamber has the power to exercise its independent judicial oversight. And this has been reiterated again in the 2016 decision regarding Burundi, and again at both levels of the Afghanistan case, especially recently in the 2020 Afghanistan appeal, where there was a differentiation made between whether a case is brought forward proprio mutuo or in state referral. And that further enhances the fact that because we don't have the equivalent of Article 15 in this case, this chamber has a further duty to assess the decisions taken by the prosecution. Your Honor, there is
You have a minute left. What I would ask you to do is focus precisely on what he knew, or what facts you rely on to prove his mens rea. Assume we know the law.
Yes, Your Honor. I would like to just reiterate the definition of what Lord Blaze needed to know and what describes his knowledge. And that is that he must have either known or consciously regarded information clearly indicated, none of which was present in this case at hand. He did not have personal knowledge. He only had administrative knowledge. And that is as far as the evidence proves. Additionally, it shows that he did not have direct responsibility, which according to the ICTY case in the MAJ means that he cannot be found criminally responsible for the case at hand. If I may be of no further assistance to the court, the defense wishes to conclude its submissions at this time, reiterating that on the basis of the evidence provided, the court should not move forward with this prosecution. Thank you.
Thank you. And I apologize for the interference to the flow of your submission. We will hear from the prosecution in rebuttal, 5 minutes.
Mr. President, Your Honors, on the first point of rebuttals, the prosecution asserts that the defense must not be allowed to simply overlook the unfavorable facts which, if considered by the court, shall establish that the contextual elements of a crime against humanity are indeed satisfied. the defense has failed to assess the scope of the contextual elements, wherein pursuant to Article 7.1 of the Rome Statute, what has to be established is that there exists a course of conduct amounting to this crime against humanity. And presently, the defense's submission did not encompass the entirety of the attacks. In order to illustrate this, the defense has erred in submitting that the attack was not primarily against a civilian population. Your Honor, this allegation is unfounded, and as seen in case facts paragraphs 4 and 5 have crystallized that even prior to the emergence of the AANG, there have already been institutionalized oppression, prohibition of fundamental human rights, and exercise of religion and belief, of which were undoubtedly conducted against civilians. Lastly, they must not be allowed to say, I quote, as long as it's incidental, it's fine, unquote. It is not fine to condone acts of hostilities conducted by states which arbitrarily infringes upon innocent civilians. Your Honor, secondly, the defense has argued that as an amnesty forms part of the transitional justice, the ICC must defer in order to preserve peace. We acknowledge that those are all valid policy arguments, but even policy arguments must be based on a sound legal basis. And at the end of the day, the question we must ask this chamber is whether the so-called amnesty proceedings fall under the definition of a trial under Article 17(1)(c). All other considerations outside of this legal assessment must not be given any legal weight in order to preserve the credibility of this court. Accordingly, as clearly stipulated in the 2010 Bemba decision on admissibility, a mere examination outside of the merits of the case is not a trial, and hence the defense's aggressive interpretation on the definition of a trial must not be accepted by this court. Lastly, as Mr. President has clearly stated, if the chamber accepts the amnesty, there will be no accountability for the crimes that has undeniably occurred. Thirdly, Your Honors, the defense's submission based on Article 53(1)(c) must not be considered, as the defense has misapplied the law. Article 53(1)(c) strictly applies to the initiation of an investigation, whereas in the present case, the proceedings against Mr. Blaze have already moved past the investigation phase, as shown in paragraph 25 of the case facts. Hence, the jurisprudence brought by the Defense Counsel, which bases the totality of their submissions that there are the 2015 Cosmoros, 2016 Burundi, the 2019 and 2020 Afghanistan situation, are all clearly distinct by means of both the trigger mechanism and the stage of proceeding, and are therefore inapplicable. And as asserted in the 2009 Darfur decision and affirmed later on in the 2020 Afghanistan appeals decision, I quote, the chamber neither has the power to review nor is it responsible for the prosecution's assessment, unquote, on the interest of justice. Hence, Your Honors, the defense's submission does not hold any legal weight, and the pre-trial chamber is not required, nor does it have the power to review. Lastly, Mr. President, my apologies. Your Honors, Mr. Blaze was not a removed individual from the superior subordinate chain with the BNS and Ms. Azila. The court must not be misled, as we see that evidently, Mr. Blaze issued the order to Ms. Azila. Mr. Blaze ordered the BNS to conduct the peace negotiations. Mr. Blaze ordered for the detainees to be transferred and later on to be released. And Mr. Blaze was the deciding factor and person in allowing for the materials to be transferred. Your Honors, Mr. President, this far supersedes the reasonable grounds to believe needed that Mr. Blaze has authority effectively materialized in the present case. The submissions brought by the defense is a tightrope stringed on a thin argument based on unsubstantive factors. Mr. Blaze had the ability to prevent, to repress, and submit the crimes, but he fails on all accounts. Mr. President, Your Honors, respectfully, the facts and laws are clear, and we rest our case. Herewith, we end our rebuttals. Thank you, and may it please the court.
Counsel, what do you say, just briefly, on defense's argument about the lack of evidence on the prosecution side, on the unsubstantiated arguments of Harrow Rock? Can the same argument that you just bestowed on the defense be turned on the prosecution as well?
Your Honor, we submit that on the prosecution side, Haru Rock's testimonies are not unsubstantiated because he has gone through these educational purposes. He has gone through these detention centers. And it can be seen that his testimony is indeed corroborated with the fact that the Far Republic their economy is based on mining and also based on mechanics and also because of the aerial footage. And so our evidence is corroborated, not unlike the defense's, Your Honor.
Where's the evidence for the corroborating facts that you just cited to?
Your Honor, respectfully, Mr. Haru Rock is a victim. We must listen to the victims. And in this case, we have to see that Mr. Haru Rock had nothing to gain, and there are others who remain unknown. And that is why we must proceed with the prosecution. Witnesses' statements, Your Honors, my apologies. Witnesses' statements are routinely relied on to meet the reasonable ground standard, notably without entering into a discussion or analysis of witnesses' credibility. As such, we invite Your Honors and this Honorable Court to the arrest warrant of Mudakumura, paragraph 66 of the Chamber, which accepts one witness's acknowledgement that in the May 2009 Burgusundi attack in particular was pursuant to Mr. Mukuramanda's order, and henceforth, similarly, being consistent with past jurisprudence, we submit that Mr. Rock's statement shall stand and be relied on to adjudicate the present case, Your Honor.
Thank you.
Thank you, Your Honor.
Now call in the defense for 5 minutes.
Your Honors, the defense has 5 points to make in rebuttal to the prosecution. Starting off, the defense would like to make clear that the defense did not simply overlook requirements of the crime against humanity of enslavement, but wishes to remind the prosecution that all of it needs to be proved under the prosecutorial burdens that are given to the prosecution when moving from the pretrial chamber to the trial chamber. Additionally, the defense would like to reaffirm the fact that stating that civilians were incidental targets of the attack is by no means fine. It is not fine that there was discrimination if there was discrimination. But we just do not believe that the discrimination that may have occurred has amounted to the level of enslavement. And it is this connection between moving from possible discrimination in detention to the crime against humanity of enslavement that is missing in evidence and that the prosecution cannot prove. Discrimination is not enslavement. And most importantly, detainment is not enslavement. Your Honors, my third point in the rebuttal concerns knowledge. In their submissions, the prosecution brought up the fact that that the requirement is that as long as Lord Blaze had knowledge of the conflict in his country, that means he had knowledge of the enslavement in the educational centers completely led by an organization, by separate organization. Knowledge of the conflict does not mean knowledge of the crime against humanity of enslavement. Of course, the conflict was happening in his country. Therefore, the defense is not content that he had knowledge of the conflict in Black Mountain, seeing as though it was a conflict between the state and an armed group. However, there is no evidence to prove that Lord Blaze had evidence of the crime against humanity of enslavement. And it is this piece of evidence that the defense states needs to be proved both when looking at the requirements for jurisdiction, as well as when looking at the requirements for knowledge under criminal responsibility found in the purview of Article 28, subsection B. Moving on to the fourth point regarding the interest of justice. Your Honors, I need to reiterate the fact that the prosecutor's decision is under the pretrial chamber is under an obligation, if it finds necessary, to exert its independent judicial oversight over the prosecutor's decision. Now, Article 53 was put in place to ensure that prosecutors did not overstep their lines when bringing a case forward. This brings us to the debate between whether a case brought forward is through a state referral or is through proprio motu, which I lightly touched on at the end of my submissions. When a case is brought proprio motu, there's Article 15 that comes into play, which asks the chamber to come and look at the evidence before the prosecutor can move forward. In the Afghanistan case, it was stated that the chamber did not have to go through an Article 53 review for interest of justice because the chamber had already reviewed at Article 15. However, this case concerned is regarding state referral, where Article 14 comes into play. Article 14 does not have such requirements regarding the chamber. Therefore, it's insinuated that the chamber definitely still has the capability under Article 53 to exercise its independent judicial oversight. Now, coming to the last point, Your Honors, regarding Heru Rock and his testimony and the lack of corroboration. The pieces of evidence available come from Ursa Azila, the Minister of Interior, and Heru Rock, a designated terrorist. Now, while we must listen to the voices of the victims, we must understand that Heru Rock is a designated terrorist. It's a difficult task to rely on the individual who allegedly committed all these crimes. But it seems equally difficult to rely on the words of an individual who had every reason to speak out against the state. The latter, we argue, is merely hearsay, and being so puts it well under the threshold of the evidence presented in this chamber. With that, the defense rests its rebuttals.
Thank you. We will now retire to deliberate on the matters on which we must deliberate, and we will get back to you in the fullness of time, but it won't be too full. Thank you.
So I will now send the judges to the deliberation room and the teams to separate breakout rooms. So the judges will be here soon.
So I think everybody's back and present. I want to thank the teams for their help during this hearing, and it aided us greatly in making our decisions. I just want to ask my fellow judges if they want to make any comments about your performances. I will make a comment, then we'll announce who the winning team is. Judge Bafadhel.
Thank you, Judge Kremer. Well, at the outset, I'd like to say a tremendous job by all speakers, very much outstanding, and references to jurisprudence and applicable law and so forth. Just in terms of kind of feedback, and also constructive feedback to help speakers along across the board, two short points really. When facing judicial intervention, try and keep the question, answers and responses as brief as possible. I appreciate you trying to answer the questions fully, but sometimes repeating the same point or the submissions you've just made cuts into your time. The second point was to faithfully cite to the evidence. There's obviously gaps in some of the evidence here, but just be careful not to sometimes make up some of the evidence in your favor. But that's all. Otherwise, like, as I said at the outset, outstanding work. Thank you.
Good, Nsereko.
I also join my fellow judge to thank the participants for their performance and their hard work. You give me a lot of hope for the future of international criminal law. I'm impressed that you've mastered the law, and of course there's still room for improvement. I'm happy that you're on top of the jurisprudence of the court. Keep it up, and I hope that it will not only be moot courts, that one day you will appear real court in one capacity or the other, and wish you well. And this one, when you are making your presentation, I know we all have notes to speak from. Don't make it obvious that you are reading, if you can help it. The judges want to see your see you. Avoid that as much as you can, to appear to be reading, even if you're reading, but don't make it obvious. And with those remarks, I thank you again and congratulate you, and wish you well in your future careers.
Thank you. On my side, I want to congratulate the teams. You kept me awake for the whole process, and that sometimes is difficult when you're aging. But you all managed your time well, notwithstanding the judicial interventions. At a hearing, you have to be, particularly time-limited hearings, you have to be very careful in how you manage your time. And you have to be aware of what you definitely have to say. And you have to be aware of ensuring that you can say it notwithstanding interruption. So you have to build in a buffer in your submissions. You did well in appearing to be natural and responsive and focused in terms of your answers to questions. And from my perspective, I was a prosecutor for the bulk of my career, either an appellate lawyer or a trial prosecutor. And my advice is always, you win cases based on the facts, not the law. And so you have to take the time to understand which facts are going to help you win the case, whether you're the defense or the prosecution, and ensure that the case reference that you use to support your legal conclusion is consistent with your factual support. And sometimes people fudge the facts in order to get the legal conclusion. Beware of that. I'm not saying anyone did it, but as you move forward and you're caught by a inquisitive judge trying to sort of test the model that you're putting forward, be careful that you don't stretch things. Take the facts and you can say it's a weak fact, but at this stage, this weak fact can carry the day. It's not for as if this was a trial where we have to prove it beyond a reasonable doubt, and that the case was entirely based on circumstantial evidence where you had to show that it was the only reasonable conclusion. So keep that in mind. I thought you were all very professional. You've got a great future ahead if you choose to go into international law. Every time I do these moot court competitions, it gives me great hope for the international law, whether you have the desire to be a defense lawyer or a prosecutor. There's opportunity there, but it requires hard work and commitment. And I'm sure you all have it, otherwise you wouldn't be participating. You've progressed far in this competition. One of the teams will get to move to the next stage, and there's hope for you to even go further. Anyway, with that, I congratulate both of the teams, and it was a difficult decision, but we have decided that the winner at this stage is the defense team N123, and congratulations. Thank you.